afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Mariah, representing the state of California. The Supreme Court should overturn the Ninth District Court of Appeals decision in Kevin Jones versus the state of California. This is true for two reasons. First of all, during Kevin Jones's interrogation with the police, he showed he was frustrated rather than clearly invoking his right to remain silent. He did this in two major ways that I'll discuss in a moment. The second reason is according to AEDPA, the Anti-Terrorism and Effective Death Penalty Act of 1996. A superior court is not allowed to overturn a lower court's judgment unless it falls into one of the two following criteria. Either the findings need to be found an unreasonable determination of the facts in light of the evidence, or the findings need to be contrary to clearly established federal law. So first, let's address this issue of frustration. We can see that during the interrogation with Kevin Jones, through his body language and through his persistently changing the story 3 times during his 2 hours and 45 minutes of interrogation, where he willingly answered questions. Finally, when he said, "I don't want to talk no more," he was showing his frustration. In fact, the police officer even had to tell him to sit up before he stated this. Even if you were to consider what was said after this statement, "I don't want to talk no more," we can see that Kevin Jones was, he interrupted the police interrogator and said, "You're not listening to me. You don't want to hear what I'm saying." This is a further indication of his frustration rather than a clear and unambiguous invocation of his rights.
So counsel, what allows us to look at the context after the alleged invocation of "I don't want to talk no more"? What allows us to do that here?
According to Smith v. Illinois, that is the case that would tell us that you can't look at context. However, we can't use Smith v. Illinois in this case because of two reasons. First of all, because the defendant showed frustration and was not unambiguously invoking his rights, which is required in Smith v. Illinois, and also because Smith v. Illinois is a right to counsel case and not a right to remain silent case, which means the court considered these two cases in completely different lines. It was only later that in 2010 with Tompkin v. Verheusen that this was actually considered more similar and that you might be able to consider it as a right to counsel case, which actually presents an even larger problem, because if we were to retroactively apply law, then we see that this would not only be against the law, but it would also create tremendous administrative problems, because we'd have thousands of convicts coming out of prison and saying, "Hey, I want a retrial." So moving on to our next point with AEDPA, as stated previously, a higher court can only overturn a lower court if the findings are contrary to clearly established law. And in 2008, there was no clearly established law to guide the lower court in their findings. Therefore, it would be completely against AEDPA to try to overturn this, or rather to maintain this case.
Isn't the clearly established law that we can look at Miranda itself? And since 1966, haven't we held that if a suspect in any manner indicates that he or she doesn't want to talk, that the interrogation must cease?
This was only established later in 2010, as I mentioned, during Tompkin v. Verheusen, when the court said you actually have to say something in order to declare your right to remain silent. However, prior to that, we don't have anything that says you clearly have to say something. So to conclude, because of what we see in his frustration, Kevin Jones' frustration in the interrogation room, as well as the AEDPA clause this court moves to reverse the 9th District Court of Appeals decision in the case of Kevin Jones.
Thank you, counsel.
Thank you.
Good afternoon.
Good afternoon.
May it please the court, Ben Tyndall representing Kevin Jones. This case deals with one of the most fundamental rights enshrined in our Constitution and the safeguards that this court has established to protect those rights. Kevin Jones was denied those rights when the California District Court of Appeals unreasonably held him to a double standard by invoking one precedent established in Davis versus the United States, while failing to protect him with another more relevant case established in Smith versus Illinois. Over 50 years ago in Miranda versus Arizona, this court found that custodial interrogation is only admissible if with the use of procedural safeguards effective to secure the privilege against self-incrimination. In this case, after hours of interrogation, our defendant, Kevin Jones, said the words, "I don't want to talk no more, man." After which, the police interrogator responded with, "I understand that, but." It is hard to see how this could be a more explicit invocation of his Miranda rights. I don't want to talk no more.
The petitioner just made a case that we can look to the context of the invocation, and in particular focused on the context preceding the alleged invocation, which was a nearly 3-hour-long interrogation of a young guy whose story was changing, etc. Why are those facts, in your view, irrelevant here for purposes of shedding light on the ambiguity of the invocation?
Because that court held Jones to a higher standard of ambiguity in invoking his right than was required in Miranda. Miranda states, when at any point during an interrogation the accused seeks affirmatively or impliedly to invoke his rights to silence or counsel, interrogation must be foregone or postponed. Furthermore, they said an accused can do this in any manner. However, the California Court of Appeals and California Supreme Court found that this statement was ambiguous because taken into context, he was expressing frustration and not unambiguously invoking his right to remain silent. However, the word ambiguous does not appear in the language of the Miranda decision. So, clearly, this court was relying on another standard that was established after Miranda in order, whether implicitly or explicitly, to hold him to a higher standard, established in Davis versus the United States, where the Supreme Court found that when invoking one's right to counsel, one must do so unambiguously. Any reasonable court familiar with Supreme Court case law would have recognized that they were applying Davis to this case. And if they were doing so, they would have also found that Smith versus Illinois was in fact a more relevant case, because Smith versus Illinois, while also dealing with Fifth Amendment Miranda right invocations, dealt with whether statements post-invocation could be used to cast ambiguity on the initial statement itself. And in Smith versus Illinois, the Supreme Court found that an accused post-request response to further interrogation may not be used to cast retrospective doubt on the clarity of the initial request itself.
So let's talk about Smith for a second, though, because one of the things that strikes me about this particular colloquy in the transcript is that there wasn't a question asked immediately after the alleged invocation. And so can we say that there was a continuing interrogation in this instance, given the lack of a question?
Yes, we can, because the police interrogator responded with, "I understand that," implying he understood that Jones was in fact invoking his right to silence by saying, "I don't want to talk anymore." But continued with the statement, "but," implying he was going to continue speaking. It's hard to imagine how that could not be understood as further interrogation, and then, since Jones continued speaking, that those further statements were used to cast doubt on the clarity of his initial request. Understandably, he did not ask a question, but he was continuing speaking, and in the manner that the interrogation had been continuing, it's hard to imagine how Jones could have interpreted that any differently.
And so what would you, in your mind, what should have happened in that moment of the invocation?
With the police interrogator?
Correct.
Questioning should have ceased, and since Miranda did not require permanent, only postponing questioning, a reasonable officer in that situation would have recognized his right, he was requesting his right to remain silent, and would have postponed questioning, further questioning until a later time. Thank you.
Thank you. All right.
All right.